everybody. This one is about martial law equals United Nations. Copies of these documents can be found in my private group at Yahoo called Administering Your Public Servants. For a complete set of YouTube videos with private information shares, a DVD with over 50 searchable law dictionaries, and other books and forums, contact me privately at engineerwin@yahoo.com. And donations to support this work are appreciated. But for all the Satanist code enforcer revenue officers operating in their private capacity under the Federal Tax Lien Act of 1966, I prefer gold or silver coin. But as an extremely less desirable alternative, I can accept the commercial paper, the IOUs, the Federal Reserve notes, the PayPal gifts, checks, money orders, etc. Send me an email for particulars. So the bottom line is that martial law is here, okay? It's in almost every nation on the planet, if not every nation. We have military government. See the Texas and other American states are under a military occupation video. See the Alberta and other Canadian states are under a military occupation video. See the martial law is here video. And martial law works on presumption. So if we had lawful government, that wasn't bankrupt, we would have common law. And under common law, you're presumed to have common law rights. But under martial law, you're presumed to be one of the slaves. That's why they want to get rid of that nasty little common law problem. And I'll show you here later on in this presentation, the biggest reason they want to get rid of that nasty little common law problem is they'd be put to death for doing what they're doing. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. And that's UCC 1-206. And so, again, everything is based on presumptions. And their presumptions are that you're one of the slaves, that you're incompetent. That's why they're representing you. They assault you with one of their liars because it admits jurisdiction. So they assault you, or they do everything they can to call it a contract and assault you with their jurisdiction and sell you into slavery. The clerk masquerading as a judge is a liar. The prosecutor is a liar. All officers of the court are bar members, and bar members are all agents of the United Nations. See the bar members videos 1, 2, and 3. A friend of mine sent this to me, and he's a lawyer, an attorney actually, or a disbarred one actually, but yeah. He sent this to me, and it said, when an attorney says, I am here to defend you, he's telling you the truth, but you're not comprehending it. The prefix D means not or un, okay? So defend means to not fend. If you stick up for yourself, you're fending for yourself. But if you defend yourself, you're allowing someone to harm you. The attorney is saying, I'm here to allow someone to harm you. That's exactly what it is. And so that's exactly what's going on. And it just goes on and on. This is a letter from the Georgia Department of Driver Services. It's been sanitized to protect people that don't need to be on YouTube videos. Anyways, the important part, it's a 3-page letter. The important part is up at the top of this page, and I have the text in a couple slides here, so I just want to show it to you. And you're welcome to stop it there and read it if you want, but that's where it's signed. Anyways, the text that I want to bring your attention to says, the statute creates a rebuttable presumption, and actually that should be all statutes create a rebuttable presumption of residency for anyone who meets the following criteria. And they go through the criteria, but the important part is what it says after. It says, however, no such person shall be considered a resident for purposes of this chapter unless such person is either a United States citizen or an alien with legal authorization from the U.S. Immigration and Naturalization Service. And that was signed by the General Counsel for the Georgia Department of Driver Services. So the bottom line is that it doesn't apply to state citizens, and we're going to talk about that. Whenever the Uniform Commercial Code, this is again UCC 1-206, did you give up your God-given rights for some satanic privileges? Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced to support a finding of its non-existence. And this is Section 3.308 of the Uniform Commercial Code. In an action with respect to an instrument, the authenticity of and authority to make each signature on the instrument are admitted unless specifically denied in the pleadings. If the validity of a signature is denied in the pleadings, the burden of establishing validity is on the person claiming validity, but the signature is presumed to be authentic and authorized. So the point being is they're forging your signature onto a contract, okay? They just make a bunch of presumptions that you're one of the slaves, and then they just go ahead and forge your signature onto a contract, and then they sell you into slavery. And they circulate their little contract, they securitize it, and sell it on Wall Street. There's people that have found their criminal case on Wall Street. The following rules apply in an action on a certificated security against the issuer. Unless specifically denied in the pleadings, each signature on a security certificate or in a necessary endorsement is admitted. If the effectiveness of a signature is put in issue, the burden of establishing effectiveness is on the party claiming under the signature, but the signature is presumed to be genuine or authorized. Okay, again, that's UCC 8.114 evidentiary rules. Okay, that's these Satanists do. And this is all coming from UNIDROIT. Okay, the Uniform Commercial Code comes from UNIDROIT. UNIDROIT stands for the Unification of Private Law. The website says that 63 countries have adopted it, and it's designed to be automatically implemented. Canada, United States are signatories to the UNIDROIT Treaty. UNIDROIT website says it's designed to be automatically implemented. And in other words, if UNIDROIT makes a change, then all of the changes just filter down through the statutes of the various countries. Okay, the 63 countries. This is the UNIDROIT website. And we'll get in a little closer, talking about commercial contracts, cultural property, franchising, and this is the next page. And if you look at the top, it says Overview UNIDROIT International Institute for the Unification of Private Law. And leasing, security interest, transport, banking law, capital markets, civil procedure. Okay, all courts fall under UNIDROIT. Contracts, cultural property, franchising, hotel keepers, insurance, intellectual property, leasing, legal status of women, maintenance obligations, movement of persons, negotiable instruments. Why do you think they want your Federal Reserve to pay that extortion? The 1955 Benelux Treaty on compulsory insurance against civil liability and motor vehicles. And this is all, again, UNIDROIT website. A 1958 Convention concerning the recognition and enforcement of decisions related to maintenance obligations towards children, okay? The 1959 European Convention on compulsory insurance against civil liability in respect of motor vehicles. So this is all going to UNIDROIT. These are the countries. This is only a couple pages out of there. I mean, there's 63 countries. But it shows that Australia, it shows most of the European countries, Canada, most of the South American countries, United Kingdom, United States, there's 63 countries. Russia. Anyways, this is Article 1 of the Libre Code, so we're going to tie this all in, the UNIDROIT, into the UNIDROIT's under the Uniform Commercial Code. That's the United Nations there by definition. Matter of fact, they're 100 yards from the Holy See in Rome. And this is Article 1 of the Libre Code. A place, district, or country occupied by an enemy stands in consequence of the occupation under martial law of the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of the hostile army proclaims its martial law. So that means any country. How many countries have been invaded at one time or another? Okay, all of Europe has. Okay, all of the Philippines, Japan, all of these countries all around the world, they've all been. I mean, why do you think all of these World War I and World War II? Why do you think that's going on? That's because they're imposing martial law in those countries. Martial law equals United Nations. And this is Article 2 of the Libre Code. Martial law does not cease during the hostile occupation except by special proclamation ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war. When the occupation of a place or territory continues beyond the conclusion of peace as one of the conditions of the same. So that's Article 2 of the Liber Code. So it doesn't cease unless A, there's a special mention of the proclamation in the Treaty of Peace, which I have never seen one yet, or B, if there's a proclamation issued by the Commander-in-Chief in the United States case, it's President of the United States. And I haven't seen one of those yet either. So it's all under martial law. And that's all satanic, and it's all coming from the UN. And further evidence is Hague Convention 4, Article 42, Law and Customs of War on Land. Territory is considered occupied when it's actually placed under authority of the hostile army. The occupation extends only to the territory where such authority has been established and can be exercised. So that's Law and Customs of War, Hague Convention 4, Article 42. This is a book called The Non-Ratification of the 14th Amendment by Judge A.H. Ella to the Utah Supreme Court in a case Diet versus Turner in 1968. And actually, this is the part of the book where he goes through all of the articles of the Liber Code. And this is, I think it's Article 3 of the Liber Code. He puts a note and makes comments on each section of the Liber Code. So this is a note, a comment on Article 3, I believe. Yes, it is. Yes, it is in Article 3 because it talks about it. Says, note, under law martial, only the criminal jurisdiction of a military court is the recognized law. But as Article 3 says, the civil courts can continually, wholly or in part, as long as the civil jurisdiction does not violate the military orders laid down by the Commander-in-Chief or one of his commanders. By this means, a military venue, jurisdiction, and authority are imposed upon the occupied populace under disguise of the ordinary civil courts and officers of the occupied district or region, because the so-called civil authorities in an occupied district or region only act at the pleasure of a military authority. It should also be noted here that the several state legislatures, county boards of commissioners, and city councils are constantly legislating to please the edicts of the federal government, which is the occupying force. This is in talking about United States in this case. And that their legislation in this sense is not an exercise of state sovereignty, but instead a compliance with the edicts of the military force which occupies the several states, and consequently are edicts of martial law rule. And so, I mean, think about it. I mean, you think it's any different in France? It's absolutely no different. It's military edicts that are going on there because of the military occupation that's been going on since the World War II. Or Belgium, or England. Well, England I'm not sure about. I'd have to think about that one. But certainly all over Europe, Spain, all of these countries that were involved in World War II were invaded. And unless they end the martial law, it's still happening. It's still there. And it's all satanic. And then you think of the Treaty of 1763 that says that everything west of the colonies, of the 13 colonies and Quebec, are Indian territory. And so then everything's under military occupation in the U.S. And then they do it other ways too, like with bankruptcies and all sorts of ways that they can bring about their martial law. And unless there's a proclamation saying that martial law ended, then it didn't. In addition to the provisions, this is Article 2 of the Geneva Convention relative to the protection of civilians in a time of war of 1949. In addition to the provisions which shall be implemented in peacetime, the present convention shall apply to all cases of declared war or of any other armed conflict which may arise between two or more of the high contracting parties, even if the state of war is not recognized by one of them. Okay, so in other words, if they're not even, like say for example, France gets invaded, so then the U.S. goes and attacks and invades France and takes it back. And so then obviously the French think they're being liberated, so they don't even know there's a state of war. And so then the U.S. sets up a government there, and that's a military occupation government is what it is, okay? They put on the charade of having elections. That's all a fraud. That's to make people think that they have some influence and they have some authority. But you notice, I've read cases, law books about how there was a common law of Europe, the common law of Denmark, a common law of Germany, and yet, when you look on maps, it's all under civil law, okay? Well, so then it's all martial law. Anyways, let's continue on. The convention shall also apply to all cases of partial or total occupation of the territory of a high contracting party, even if the said occupation meets with no armed resistance. Although one of the powers in conflict may not be a party to the present convention, the powers who are parties thereto shall remain bound by it in their mutual relations. They shall furthermore be bound by the convention in relation to said power if the latter accepts and applies the provisions thereof. And so whether they're a party to the convention or not, they're still bound to follow the rules. And that applies to like Canada, okay, everything west of say Quebec, okay. Matter of fact, Quebec in the Treaty of 1763 of the map of, not the treaty, the proclamation, the Royal Proclamation of 1763. And so the point being is that there's an occupying force. The First Nations people that were there had no idea that they were being invaded, that they were being made war on, and so they didn't recognize it. And they didn't have armed resistance except maybe occasionally when the Indians would start to put up some resistance. And so the bottom line is that it's all military occupation, and they put on these charade, this fraud of elections, and all the rest of it is just a charade, and to make people think they have some they're self-governing and all the rest of it, and it's really a military occupation. This is Article 6 of the Geneva Convention relative to the protection of civilians in a time of war. The present convention shall apply from the outset of any conflict or occupation mentioned in Article 2. In the territory of parties to the conflict, the application of the present convention shall cease on the general close of military operations. In the case of occupied territory, the application of the present convention shall cease 1 year after the general close of military operations. However, the occupying power shall be bound for the duration of the occupation, to the extent that such power exercises the functions of government in such territory by the provisions of the following articles of the present convention. And so there's a whole bunch of articles that continue to bind the occupying power forever, okay? And in Canada's case, hundreds of years. In other countries, I'm sure there's hundreds of years, maybe even thousands of years if you can show it, okay? You got to show it. But the bottom line is that all of this was it's all run by the UN. And this is Article 27, okay? This is, see, one of those articles that are bound by the provisions is 1 through 12, 27, 29 to 34, okay? We're only going to talk about a couple of them here. Article 27, without prejudice to the provisions relating to their state of health, age, and sex, all protected persons shall be treated with the same consideration by the party to the conflict in whose power they are, without any adverse distinction based on race, religion, or political opinion. Well, and so, I mean, you find that in statutes, actually, and they go and so all of that stuff is codified in statutes. But again, if you don't assert your rights, these people are Satanists. You know, they want to make money for their handlers. This is Article 33. No protected person may be punished for an offense he or she has not personally committed. Collective penalties and likewise all measures of intimidation or of terrorism are prohibited. Pillage is prohibited. Reprisals against protected persons and their property are prohibited. And that's Article 33 of the Geneva Convention relative to the protection of civilians in time of war. Pillage is when they steal your property like the border pigs in Canada do. And they assault you with their Sesticate Trust, with their fraudulently created Sesticate Trust. And so it's really their Sesticate Trust that's committed. That's why they got to get you into one of their so-called contracts. And we're going to talk about that in here. And it goes back to the Roman cult. Okay, this is the papal bull Dum Diversus, 18th of June, 1452. This is when slavery started. Okay, actually, slavery goes back to the Roman Empire, but here's the documented proof of it starting in 1452. And this is Pope Nicholas V issued the papal bull Dum Diversus on 18th of June, 1452. It authorizes Alfonso V of Portugal to reduce any basically Muslims, pagans, or any unbelievers, okay, anybody who's not part of the Roman cult, one of their universal church lackeys, anyways, do perpetual slavery, okay. This facilitated the Portuguese slave trade from West Africa. That's how it all got started. This same pope wrote the bull Romanus Pontifex on January 5th, 1455, to the same Alfonso as a follow-up to the Dum Diversus. It extended to the Catholic nations of Europe domination over discovered lands during the Age of Discovery. Along with sanctifying the seizure of non-Christian lands, it encouraged the enslavement of native non-Christian peoples in Africa and the New World. We weighing all the singular premises with due mediation, and noting that since we had formerly by our letters of ours granted among the other things free and ample faculty to the aforesaid King Alfonso to invade, search out, capture, vanquish, and subdue all Saracens and pagans whatsoever, and other enemies of Christ wheresoever placed, in other words, anybody who's not Catholic, and wherever placed, and the kingdoms, dukedoms, principalities, dominions, possessions, and all movable and immovable goods whatsoever held and possessed by them, and to reduce their persons to perpetual slavery, and to apply and appropriate to himself and his successors the kingdoms, dukedoms, counties, principalities, dominions, possessions, and goods, and to convert them to his and their use and profit, to steal everything they can get their hands on. And by having secured the said faculty, the said King Alfonso, by his authority, the aforesaid infant justly and lawfully has acquired and possessed, and doth possess these lands, islands, lands, harbors, and seas, and they do of right and belong to said King Alfonso and his successors. Have you ever heard of the gold, the ships that were laden with gold and treasure that went from the Americas over to Europe, to Spain and Portugal in the 15s and 1600s? This is where it all got started. In 1493, Alexander VI issued the bull Intercatera, stating one Christian nation did not have the right to establish dominion over lands previously dominated by another Christian nation, thus establishing the law of nations, okay? This is where the law of nations got started. Certainly, the law of nations consists of treaties between nations, okay? That's called the treaty collection, or the treaty, I can't remember, but it's at the UN. It's a treaty collection. Anyways, but there's more than just the treaty collection, and that's where this started, the law of nations. Together with the Dum Diversus, the Romanus Pontifex, and the Inter Cetera came to serve as the basis and justification for the doctrine of discovery, the global slave trade of the 15th and 16th centuries, and the age of imperialism. And this is a book called The Lines of Demarcation of Pope Alexander VI and the Treaty of Tordesillas by Samuel Edwards Dawson. And it's from the Transactions of the Royal Society of Canada, Volume 2, Section 2. Okay, so it's 1899. Anyways, on page 471 of this book, it says, if therefore we put aside the conventional law or treaty law of nations, it will be seen that modern international law is founded on the Roman law and on the canon law, which latter was carried over all Europe by the Roman Church, for even in England up to the time of Edward III, the Lord Chancellor was always a Roman cult. Okay? And so, and this is a Wikipedia page about Alberico Gentili, who was recognized as the founder of the science of international law. Gentili is perhaps most influential people in legal education ever to have lived. He's one of three men referred to as the father of international law. He was the earliest writer on public international law, the first person to split secularism from canon law and from Catholic theology, okay? And then it goes on, and if you read down here at the bottom, it says he practiced in the High Court of Admiralty. We'll start at that paragraph. Gentili held a Regius professorship until his death, but he turned more and more to practical work in London from about 1590. He practiced in the High Court of Admiralty, where the continental civil law rather than the English common law was applied. Yeah, I mean, again, these Satanists don't want to have anything to do with common law, and that's where it comes into Admiralty, okay? And so, again, that's the law of war, basically. Statutes of the International Law Commission, 1947. The International Law Commission shall have for its object the promotion of the progressive development of the international law and its codification. The Commission shall concern itself primarily with public international law, but is not precluded from entering the field of private international law. And that's all found in Article 1. Well, private international law is UNIDROIT. Okay, that's what that is. And here is the Hague Conference on Private International Law, a convention concerning the international administration of estates of deceased persons. And it talks about the international certificate, okay? That's the birth certificate, okay? And then if you go to the bottom, it has this footnote 1, and we're going to get into that here. We'll show this a little closer, first of all. So the international certificate, that's the birth certificate. And this convention, including related materials, is accessible on the website of the Hague Conference on Private International Law under Conventions. For the full history of the convention, see Hague Conference on Private International Law. And so the Hague Convention concerning the international administration of deceased persons, Article 23, says any person who pays or delivers property to the holder of the certificate drawn up and, where necessary, recognized in accordance with the convention shall be discharged until it is proved that the person acted in bad faith, okay? Article 22, Article 23, any person who has acquired assets of the estate from the holder of the certificate drawn up and, where necessary, recognized in accordance with this convention shall, unless it is proved that he acted in bad faith, be doomed to have acquired them from a person having power to dispose of them. Okay, so the bottom line is these birth certificates all fall under the United Nations. Okay, now all of this stuff is all coming from the UN, is where it's coming from. And here they're talking about collecting money from this certificate. Okay, they circulate them on Wall Street and sell them and make money off of them. Convention on the law applicable to trusts and their recognition. This is all more stuff on trusts and UNIDROIT. Concluded 1st of July 1985, entered into force 1st of January 1992, in witness whereof the undersigned, being duly authorized thereto, have signed this convention, okay? And so, again, this is done at The Hague on the 1st day of July 1985 in English and French, both texts being equally authentic in a single copy, which shall be deposited in the archives of the government of the Kingdom of the Netherlands, of which a certified copy shall be sent through diplomatic channels to each of the states members of the Hague Conference on Private International Law at the date of its 15th session. And so, now a little diversion. Don't forget to subscribe to this channel. Don't forget to like this video with the thumbs up. Don't forget to click the bell next to the subscribe button so that you're notified when there's a new upload. And there's the front page of the channel, and there's the arrow pointing to the bell. You click on that, a pop-up will come up, and you can subscribe so you're notified about new uploads. Anyway, so this is the more United Nations stuff. This is the International Covenant on Civil and Political Rights, Article 1, Clause 1 and Clause 3. Clause 1 says all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. And then Clause 3 says the state parties of the present covenant, including those having responsibility for the administration of non-self-governing and trust territories, well, that's places that are occupied under military occupation, shall promote the realization of the right of self-determination and shall respect the right in conformity with the provisions of the Charter of the UN. And so this is the same. It's Article 2, Clause 1. Each state party shall, to the present covenant, undertakes to respect and to ensure all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national, social origin, property, birth, or other status. Okay, this is all Roman law. This is municipal law. This is all Roman cult. It's all coming from the UN. Article 2, Clause 2, were not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So they pass all sorts of laws, and you can see those laws all over the place. This is this International Covenant on Civil and Political Rights, Article 2, Clause 3. Each state party to the present covenant undertakes to ensure that any person whose rights or freedoms are as herein recognized or violated shall have an effective remedy, notwithstanding that the violation is committed by persons acting in an official capacity. B, to ensure that any person claiming such a remedy shall have his right thereto determined by competent judicial bought and paid for whores or by other competent authority. To ensure that the competent authority shall enforce such remedies when granted. The state parties to the present covenant, and this is Article 3, undertake to ensure that all right of men and women to the enjoyment of all civil and political rights set forth in the present covenant. And so, again, they want to assault men and women with their person status. Matter of fact, here it is in Article 16. Everyone shall have the right to recognition everywhere as a person. Okay, so they assault you with their person. And this is Article 15. No one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a criminal offense under the national or international law at the time when it was committed. And then nothing in this article shall prejudice the trial and publish punishment of any person. And they always put in this little disclaimers all over the place, eh? So this stuff really means nothing because they can. There's always these little outs. And this is actually Covert Geopolitics, a website that I found, and it's the death of London's Roman Empire by Lyndon H. LaRouche Jr. Okay, so again, this is all coming from the Roman cult, and it's the United Nations is where it's all coming from. And now another little diversion. Announcing a subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is only $1.99 a month because it only avoids the advertising. Originally, when I set it up, I was planning on having some exclusive content, but I can't think of anything that I want to have it on there exclusively. My agenda is to expose these New World Order Satanists and for all the fraud that they're involved in. And so there's nothing that I want to have on there exclusively. I do have a couple things. I've got a Arlington private information share, and I've got a video on how to do affidavits. And but that's it. And so the only thing I can guarantee is that you'll be able to avoid the advertising. If you want to make a donation of $1.99 a month, it's certainly appreciated. If you want to, if you just want to avoid the advertising, then that's the way that you can do it. I've had some people complain about the ads. I don't put that many up there, but I've seen videos with a lot more than what I put up, quite frankly. Anyways, so I'm currently publishing 5 videos a week, and some people had trouble finding the channel, so a link is at the bottom of this page and at the top of this page. And now the start free trial button, I pointed that out with the arrow because somebody actually sent me $1.99, and I wasn't sure if they wanted me to sign them up or if they just wanted to make a donation or what. And so I actually offered to refund it because I really have no control over the subscribers to this channel. I can't even see all of them. I have no control at all. It's all under YouTube's control, and so you're going to have to click that if you want to subscribe, and they're probably going to want some payment arrangements or who knows what. But it's going to be it's completely out of my control. Anyways, back to the topic at hand. This is Article 18 of the International Covenant on Civil and Political Rights. Everyone shall have the right to freedom of thought, conscience, and religion, and this right shall include freedom to have or adopt a religion or belief of his choice. And then no one shall be subject to coercion which would impair his freedom to have or adopt a religion or belief of his choice. And so, but they always put these little escape clauses in there. Matter of fact, this is paragraph 4 of Article 18 says the state parties to the present covenant undertake to have respect for the liberty of parents when applicable, legal guardians to ensure religious and moral education of their children in conformity with their own convictions. And then clause 3 says freedom to manifest one's religion or beliefs may be subject only to such limitations. And so that's where they got these little escape clauses. Okay, at common law, it's an absolute right, and they haven't got anything to say about it. But these Satanists, they like to put out their smoke and mirrors. Anyways, this is Article 24. Every child shall have, without any discrimination as to race, color, sex, language, religion, national origin, property, or birth, the right to such measures of protection is required by his status. Okay, this is all coming from the Roman cult. It's all Roman law. Every person, clause 2, every child shall be registered immediately. Okay, they want to create that collateral. They want those birth certificates. Okay, every child shall have the right to acquire nationality. This is Article 26. All persons are equal before the law. See, they want to assault you with their person. If you want to read that, you're welcome to. But it's all persons. It's all Roman law, and you can see there's statutes that cover all of this. And then Article 26, in those states in which ethnic, religious, or linguistic minorities exist, persons belonging to such minorities shall not be denied the right in community with other members of their group to enjoy their own culture, to profess and practice their own religion, or to use their own language. And now another little diversion, CubeYard.com. For great custom websites, domain names, and hosting, go to CubeYard.com. Use coupon code CY172 for 20% off your first order. CubeYard.com, your source for websites, domain names, and hosting. And then now this is talking in the U.S. international law rule, okay, because they need this U.S. citizen, okay, is the person that this international covenants are all talking about. The international law rule adopted for areas under federal legislative jurisdiction federalizes state civil law, including common law. The rule serves to federalize not only the statutory but the common law of a state. State and federal venue discussed. The civil laws effective in an area of exclusive federal jurisdiction are federal law, notwithstanding their derivation from state laws, and a cause arising under such laws may be brought in or removed to federal district court. Now, this is taken from Jurisdiction over Federal Areas Within the States, Report of Interdepartmental Committee for the Study of Jurisdiction over Federal Areas Within the States, Part 2, a text of the Law of Legislative Jurisdiction submitted to the Attorney General and transmitted to the President June 1957, and that's pages 158 through 165. Now, so you're sitting there thinking, I'll bet, that this talks about exclusive federal jurisdiction, right? Well, that means anywhere in America. And this is National Mutual Insurance Company, District of Columbia versus Tidewater Transfer Company, 1948, U.S. Supreme Court. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states were not included in the catalog of controversies over which the Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power, that's military dictatorship, folks, covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. So it doesn't matter where you're at. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That's the 14th Amendment. See, the so-called 14th Amendment is unconstitutional video. U.S. citizens are enemies of the state. A U.S. citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the Public Charitable Trust, the Constructive Cestacate Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. And that's a summary of 5 pages of the congressional record dated June 13th, 1967. And let me stress summary, you know. People keep contacting me about this. And hello, the lights are on. Is anybody home? It's a summary. Every taxpayer is assessed a trust having sufficient interest in the preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. That's Henry Boland's 1912. Slater's protestations to the effect that he derives no benefit from the United States government have no bearing on his legal obligation to pay income taxes. Unless the defendant can establish that he's not a citizen of the United States, the IRS possesses authority to attempt to determine his federal tax liability. And so they assault you with their U.S. citizen slave and then steal your property. And then this is the D.C. Code, an act to establish a code of law. This is a U.S. citizen's Sestake Trust, and this is Chapter 56, Section 1617, located at 31 Stat, 1432, the legal estate to be in the Sestake use. And this is D.C. Code again. This is approved March 3rd, 1901, 56 Congress, 31 Stat 1189, and it's at Section 2, where it says, be it further enacted that in interpretation and construction of said code, the following rules shall be observed, namely, third, the word person shall be held to apply to partnerships and corporations. And more D.C. Code, absence of 7 years at Section 252, located at 31 Stat 1230, and so we're talking, it goes to, this is at 1189 to 1230, so then you're talking, 50 pages later. And presumption of death, okay? And so, again, it's talking about Sestake Trust is a dead thing, and so they can presume you're dead. And so, again, it comes down to presumptions. Remember, we talked about that already? And so this gives them the right to presume you're dead. And this is, did you give up your God-given rights for some satanic privileges? This is Title 15, United States Code, Section 44, definitions. A corporation shall be deemed to include any company, trust, so-called Massachusetts trust or association, incorporated or unincorporated, which is organized to carry on business for its own profit or that of its members, and has shares of capital, capital stock, or certificates of interest, and any company, and it goes through the exact same definition except it doesn't have shares of capital stock, capital stock or certificates of interest. Okay, so that's what that definition says. So that's a trust, okay, among other things. It could be a lot of things, but a trust, a Sestake Trust, is included in that definition. And this is the Sestake v. Trust Act of 1666, and this is recital that Sestake V's have gone beyond the sea. Okay, so this is all admiralty, and that reversioners can find out whether they're alive or dead. And so then this is a second page of the Sestake v. Trust Act. And so remaining beyond the sea for 7 years together and no proof of their lives, the judges enact action to direct a verdict as though the Sestake v. were dead. And so the Sestake v., they can assault you with the Sestake v. Trust whether you're living or dead, okay, because they're saying right here is no proof of their lives, the Sestake v., okay, and so you could be dead or alive, and they assault you with their Sestake v. Trust, okay, and they're saying in here that they can treat the trust as if it's dead, okay, so they assault you with their fictitious entity, and so then they can steal your property. And yet, still, it was found difficult to set bounds to ecclesiastical ingenuity. That's Roman cult, folks. For when they were driven out of all their former holes, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses. That's the Roman cult, folks. Thus distinguishing between the possession and the use, and receiving the actual profits while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, the Roman cult, folks, to be bound in conscience to account to his Sestake use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And it's still the foundation of modern conveyancing. And they're using that Sestake Trust all over the place. And it's found in international law. And it's all coming from the United Nations. And that's taken from Tomlin's Law Dictionary, 1835 edition, Volume 2, under the definition of mort main. And so, a little intermediate summary. All persons are sesticate trusts and they're aliens. Okay, all statutes are for regulating aliens. All statutes are international law. All courts are dealing with international law. All judges fall under the United Nations and United Nations treaties. Martial law is coming from the United Nations. And now another little diversion. Check out my other videos, Bankster Thieves 1, 2, and 3, Roman Cult Slave Scam Series. There's 2 of those right now. Bankrupt Corporate So-Called Governments, Bar Members 1 through 3. Do it yourself, How Not to Volunteer for the Selective Service in the Draft. Martial law is here. Do it yourself, No Income Tax. Do it yourself, No Sales Tax. Do it yourself, Traffic Stop 1 and 2. Do it yourself, Free Mail 1 and 2. And do it yourself, Kangaroo Courts 1 through 9. So there's no common law crimes in the United States. There's no common law offenses against the United States. Only those acts which Congress has forbidden with penalties for disobedience of its crimes of its command are crimes. Under Texas law, no act or omission is a crime unless made so by statute. The legislature can create an offense and in the same enactment provide exceptions to its application. Okay, so the same thing as in Texas, same thing as in every other state. Everything is an admiralty. It's a military occupation. A writ of error doth not lie upon a sentence in admiralty, but appeal. Now that's cited from Tomlin's Law Dictionary 1835 edition under the definition of admiralty, but they are citing Book 4 of Coke's Institutes on the Laws of England. That goes back to the 1500s. Appeals are an admiralty. That's why it's called a court of appeals. It's the same thing that precipitated the War of Independence. This is taken from the Causes and Necessities for Taking Up Arms, 1775. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use of the exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the miseries to which such despotism would reduce us. And so, again, this is what precipitated the War of Independence, and martial law is satanic, okay? Martial law is satanic. And this non-ratification of the 14th Amendment by Judge H. Ellett of the Utah Supreme Court in his case Diet versus Turner, he explains the same thing a little bit differently. And this is exactly what's going on. It says, in the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying what's common law and leaving what's called equity in its place. And that's why it's satanic. And that's why there's no common law statutes. The common law doesn't apply. The only common law that applies is stuff they put in a statute. And there's all sorts of statutes for common law crimes like murder, kidnapping, false imprisonment, and then there's common law crimes like infanticide that they kind of conveniently forget to put in there because they want to kill your babies. And so that's exactly what these Satanists do. And so this is all coming from the Roman cult. This is all satanic, where the clerk masquerading as a judge gets to sit there and play stupid. And if you don't know the law, and if you don't, his presumptions that you're one of the slaves, and they just railroad you and sell you into slavery. This is all satanic. A penal action is an action on a penal statute, an action for recovery of penalty given by statute, where an action is founded entirely upon a statute. The only object is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty in their strict and primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture or to be forfeited for non-compliance with an agreement. They assault you with one of their contracts. The words forfeit and penalty are substantially synonymous. And so a penal action is one founded entirely on statute, and the only object is to recover a penalty or a forfeiture imposed as a punishment for a certain specific offense, while a remedial action is one which is brought to obtain compensation or indemnity. A penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as a punishment for an offense against the public. Such actions are civil actions, on the one hand closely related to criminal prosecutions, and on the other to actions for private injuries, in which the party aggrieved may by statute recover punitive damages. And so that's why the bail priest Satanist whore in these kangaroo courts, when you ask him what the nature of it is, he says, oh, it's quasi-criminal. And that's why he won't come out and tell you this is a civil suit, because they can't, with a civil suit, there's nothing they can do. They can steal your property, that's it. But individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights, duties, and privileges of the artificial entity or association over which they're agents or officers, and they're bound by its obligations. And that's Braswell versus United States. And this is coming from the Supreme Court, bail priests, and this is how they assault you. When you go in there and you say, yes, I am the name, then they just got you in a contract. You agreed to it. That's exactly what happens, and now it's all the terms of the contract. That's what it is. Now we're debating the terms of the contract, and they can make it up as they go along. Did you give up your God-given rights for some satanic privileges? Whenever the Uniform Commercial Code creates a presumption with respect to a fact, or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. That's UCC 1-206. Did you give up your God-given rights for some satanic privileges? And this is my contact information. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo. My YouTube profiles, I've got two of them, Sovereign Living and Sovereignty International. My Facebook community page, I deleted it due to censorship on the part of the Facebook, the CIA owned and operated Facebook. And my private group called Sovereignty International on Facebook is in the process of being deleted. It takes time to ban 17,000 people off your group, and I'm not going to let Facebook profit from my hard work. My Yahoo private group is administering your public servants, and my Google private group is administering your public servants. And follow me on Twitter at EngineerWin. So this is Uniform Commercial Code 3.308. In an action with respect to an instrument, the authenticity of and authority to make each signature on the instrument are admitted, unless specifically denied in the pleadings. If the validity of a signature is denied in the pleadings, the burden of establishing validity is on the person claiming validity, but the signature is presumed to be authentic and authorized. And so the point being is that they forge your signature onto a contract. You don't even know that's what's going on. That's what these Satanists do. The following rules apply in an action on a certificated security, and they're circulating it on Wall Street. They're selling it, and Wall Street's making them money on the thing. Unless specifically denied in the pleadings, each signature on a security certificate or a necessary endorsement is admitted. If the effectiveness of a signature is put in issue, the burden of establishing effectiveness is on the party claiming under the signature, but the signature is presumed to be genuine and authorized. So they forge your signature onto a contract, they securitize it, they sell it on Wall Street, and you get to go to jail, and they sell you into slavery. That's exactly what these Satanists do. These Roman cult Satanist bar member whores masquerading as a judge forges your signature onto a contract and then presumes it's authorized or authentic. Who's going to call a judge a liar? That's how they're populating the prisons. Carl Lentz brought up the issue of forgery against CPS when they stole his son in his successful one-page lawsuit. See the Judicial Horrors video. Did you give up your God-given rights for some satanic privileges? He, the convicted felon, has as a consequence, or anybody in jail, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law in its humanity affords him. He is, for the time being, a slave of the state. Okay? They are selling you into slavery. The prisons are full of slaves. That's exactly what these Satanists do. This is all coming from the Roman cult. That's why they want to get rid of this common law problem, this nasty little common law problem. We don't want to have God's law around here. We want to have satanic martial law. Because if a man be found stealing any of his brethren of the children of Israel, and maketh merchandise of him or selleth him, then that thief shall die. Thou shalt put evil away from among you. They would be put to death. And we, the people, need to start stepping up and taking care of business here. We're going to reap the judgments that are justly due. International law is a subset of canon law. International law started with the Roman cult. UNIDROIT stands for the International Institute for the Unification of Private Law. UNIDROIT is located 100 yards from the Holy See. UNIDROIT controls and governs the Uniform Commercial Code. Through UNIDROIT, the Roman cult has seized control of all courts. The Roman cult's bar members are already officers of all courts. See bar members videos 1, 2, and 3. The United Nations is owned and operated by the Crown and the Roman cult handlers. See the Crown is owned and operated by the Roman cult video. See, the United States is a Crown colony, and the Crown owns and operates the United Nations 1 and 2 videos. UNIDROIT is coming from the United Nations. See the Roman cult slave scam 1 video. United Nations maintains the international law collection, which is also coming from the Roman cult. They are using the Roman cult's international law rule to assault us with their fraudulent, fictitious, Sestake Trust U.S. citizen slave. Get us out of the UN now. This is the Vatican's Holocaust, written by Avro Manhattan. It's a sensational account of the most horrifying religious massacre of the 20th century. This is the kind of stuff the Roman cult does. This is all about business for these Roman cult Satanists. Avro Manhattan was the world's foremost authority on Catholic Roman Catholicism and politics, a resident of London during World War II. He operated a radio station called Radio Freedom, broadcasting to occupied Europe. He was the author of over 20 books, including the bestseller The Vatican and World Politics, twice Book of the Month, and going through 57 editions. He was a Great Britain who risked his life daily to expose some of the darkest secrets of the papacy. His books were #1 in the Forbidden Index for the past 50 years. And I guess the editor's note in 2006, it was 70 years, and it's 2016 now, so it's probably 80 years. Anyways, preface to the American edition, the Vatican's Holocaust is not a misnomer, an accusation, and even less a speculation. It is an historical fact. Rabid nationalism and religious dogmatism were its two main ingredients. During the existence of Croatia and as an independent Catholic state, over 700,000 men, women, and children perished. Many were executed, tortured, died of starvation, buried alive, and were burned to death. Hundreds were forced to become Catholic. Catholic padres ran concentration camps. Catholic priests were officers in the military corps, which committed such atrocities. 700,000 in a total population of a few million proportionally would be as if 1/3 of the USA population had been exterminated by a Catholic militia. What has been gathered in this book will vindicate the veracity of these facts. Dates, names, places, as well as photos were there to prove them. They should become known to the American public, not to foster vindictiveness, but to warn them of the danger between racialism and sectarianism when allied with religious intolerance can bring any contemporary nation, whether in Europe or the New World. This work should be assessed without prejudice as to the lesson, but even more vital as to a warning for a future of Americans, beginning with that of the USA. Avro Manhattan, 1986. And I want to stress here that this has nothing to say about people that happen to be Catholic, but the Roman cult is definitely satanic. And there's friends of mine that happen to be Catholic, some of my best friends, and they're the ones that are feeding me this information. And the editor's note, an armed Serbia could have easily prevented this Holocaust. Thank God for the Second Amendment to the Constitution, which guarantees the right to bear arms. Freedom of religion and armed citizenry go hand in hand and is the only guarantee that this won't happen in the U.S. Editor's note, It is the Vatican one world government that doesn't want you to have the right to own arms or to use any means to defend yourself. And ain't that the truth? That's the Roman cult. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. The government of the United States is one of limited powers. It can exercise authority over no subjects except those which have been delegated to it. Congress cannot by legislation enlarge the federal jurisdiction, nor can it be enlarged under the treaty-making power. No treaties internationally. That's Mayor of New Orleans versus United States. Did you give up your God-given rights for some satanic privileges? So they're assaulting us with their treaty-making power, and that's unconstitutional. But Madison insisted that just because this power was given to Congress, it did not follow the treaty power was absolute and unlimited. The President and the Senate lacked the power to dismember the empire. For example, because the exercising of the power must be consistent with the object of the delegation, the object of treaties in Madison's oft-repeated formulation is the regulation of intercourse with foreign nations and is external. And that's 2014 case, Bond versus United States. Did you give up your God-given rights for some satanic privileges? Today, it's enough to highlight some of the structural and historical evidence suggesting that the treaty power can be used to arrange intercourse with other nations, but not to regulate purely domestic affairs. And again, that's Bond versus United States. No treaty power internally. See the no treaty power inside USA video. Did you give up your God-given rights for some satanic privileges? Downs versus Bidwell, the dissenting opinion of Justice Marshall Harlan. Two national governments exist. One to be maintained under the Constitution with all its restrictions. The other to be maintained by Congress outside and independently of that instrument. Why do you think that Nancy Pelosi, as Speaker of the U.S. House of Representatives, said they have to pass legislation so they can find out what it says? Did you give up your God-given rights for some satanic privileges? All of these statutes about freedom of religion are a cheap imitation of common law and essentially convert rights into privileges. This is non-ratification of the 14th Amendment by Judge H. Ellard of the Utah Supreme Court in the case Diet versus Turner. By this means, citizens' birthrights become of no effect and their rights are reduced to the inferior character of statutory civil rights, mere legislative privileges. At common law, there are absolute rights. Statutes can and are changed. Statutes are ignored. And so they want to get you comfortable with their Roman civil law, and then after people have gone asleep, they'll go ahead and just make all sorts of changes and enslave you. It's all about slavery. It's all coming from the Roman cult. History is clear that the first 10 amendments to the Constitution were adopted to secure certain common law rights of the people against invasion by the federal government. Every citizen and freeman is endowed with certain rights and privileges to enjoy, which no written law or statute is required. These are the fundamental or natural rights recognized among all free people. The people are sovereign and not bound by general words and statutes restrictive of prerogative, right, title, or interest, unless expressly named. Acts of limitation do not bind the king or the people. The people have been ceded all the rights of the king, the former sovereign. And that's People versus Herkimer, and that's New York Court Case 1825. Taxpayers are not state citizens. Did you give up your God-given right for some satanic privileges? State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision. U.S. Supreme Court, Twining versus New Jersey, whose rights are incapable of impairment by legislation or judicial decision. And state citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. And that's Spavot versus Kingsbury. Cruden versus Neal. The state citizen is immune from any and all government attacks and procedure absent contract. Every man is independent of all laws except those prescribed by nature. He's not bound by any institutions formed by his fellow men without his consent. Did you give up your God-given rights for some satanic privileges? The rights of individuals are restricted only to the extent that they've been voluntarily surrendered by citizenship to the agencies of government. Did you give up your God-given rights for some satanic privileges? The people are sovereign and not bound by general words and statutes restrictive of prerogative, right, title, or interest unless expressly named. Acts of limitation do not bind the king or the people. The people have been ceded all the rights of the king, the former sovereign. It will be admitted on all hands that with the exception of the powers granted to the states and the federal government through the constitutions, the people of the several states are unconditionally sovereign within their respective states. Did you give up your God-given rights for some satanic privileges? A sovereign is exempt from suit not because of any formal conception or obsolete theory, but on the logical and practical ground that there could be no legal right as against the authority that makes the law on which the right depends. And that's U.S. Supreme Court, Kawanakoa versus Polyblank. Did you give up your God-given rights for some satanic privileges? Remember that all power that the government has is delegated. Do I have the authority to steal your property? No, I do not. Then neither does the government. At the revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. Did you give up your God-given right for some satanic privileges? People of a state are entitled to all the rights which formerly belonged to the king by his prerogative, and that's Lansing versus Smith. Do you know who you are playlist? One may be a citizen of a state and not a citizen of the United States. Did you give up your God-given rights for some satanic privileges? Privilege and Immunities Clause of the 14th Amendment protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. Did you give up your God-given rights for some satanic privileges? Merely being native-born within the territorial boundaries of the United States of America does not make such an inhabitant a citizen of the United States subject to the jurisdiction of the 14th Amendment. And that's U.S. Supreme Court, Elk versus Wilkins. There is in our political system a government of each of the several states and a government of the United States. Each is distinct from the other and has citizens of its own. Did you give up your God-given right for some satanic privileges? One may be a citizen of a state and not a citizen of the United States. That's McDonald versus State. Both before and after the 14th Amendment to the federal Constitution, it has not been necessary for a person to be a citizen of the U.S. in order to be a citizen of his state. A person who is a citizen of the United States is necessarily a citizen of a particular state in which he resides, but a person may be a citizen of a particular state and not a citizen of the United States. To hold otherwise would be to deny to the state the highest exercise of its sovereignty, the right to declare who are its citizens. And that's State versus Fowler, 1889. Did you give up your God-given right for some satanic privileges? Eliminating then from the opinions of this court all expressions unnecessary to the disposition of the particular case, and gleaning therefrom the exact point decided in each of the following propositions may be considered as established. Number one, that the District of Columbia and the territories are not states within the judicial clause of the Constitution giving jurisdiction in cases between citizens of different states. In other words, if you're a U.S. citizen or you're in the District of Columbia or one of the territories, if you're a U.S. citizen and anywhere, you don't have a court, okay? It's not a court. The Article 3 doesn't apply. It's a kangaroo court. And then paragraph 3, it says, the District of Columbia and the territories are states, as that word is used in treaties with foreign powers with respect to the ownership, disposition, and inheritance of property. Well, gee, that sounds like a Sestake trust. And that is talking about, if you read in the D.C. codes, it talks about how United States includes one of the states of the Union, and then it'll list them. It'll say Guam, American Samoa, and Puerto Rico. But most people are too stupid to figure that out because they're just listing them twice is what they're doing. That the territories are not within the clause of the Constitution providing for the creation of a Supreme Court and such inferior courts as Congress may see fit to establish. And so, again, the Supreme Court, the U.S. Supreme Court is really a D.C. Supreme Court, okay? And it's a bunch of clerks masquerading as judges. The territories are not within the clause of the Constitution for the creation of Supreme Court and inferior courts. There are no courts in the District of Columbia and the territories. It's all, that's why John Roberts could get up there and say that Obamacare was just another tax, okay? Because it's not a court, okay? It's and you rule in there in Rule 45 of the Supreme Court rules. It says right in there that all mandates from the Supreme Court come under authority of the President of the United States, which means that they are bought and paid for. Nothing to do with the United States has anything to do with state citizens. Did you give up your God-given rights for some satanic privileges? United States participation in the United Nations only applies to U.S. citizens. There are no real courts in the District of Columbia and the territories. There are only kangaroo courts. A kangaroo court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the bias of the court or other tribunal. That's Black's Law Dictionary, 6th edition. Anyways, that's the end of it. I appreciate you watching. Martial law is all coming from the United Nations and the Roman cult, and we need to put a stop to it. It's all satanic, and we need to put a stop to it. Thanks for watching. Spread the word. Have a great day.